Hello and welcome. I'm Arden Mitchell and I serve as Executive Director and CEO of Arden Wood. Today's presentation is the second of 3 webinars focusing on key aspects of estate planning. Welcome back if you joined us last week, and welcome if you're new today. If you missed last week's webinar, the replay is on our website, ardenwood.org, under Events. Or if you need help, please feel free to email us at info@art.org. You know, estate planning is not always an easy subject to talk about, but it's absolutely essential to do it. I've personally witnessed the disastrous effects of not planning too many times. And I literally just got off the phone this afternoon with a donor who said she hasn't talked to her brother in over 14 years due to a misunderstanding over an estate issue. There is no reason for that in this human experience. No reason. As the saying goes, if you don't have a plan, the state has a plan for you. In other words, if you don't take the time to decide where your valuables and savings will go, the state will claim an unreasonable amount through taxation. And nobody wants that. Before we begin, I want to give you an update. You'll soon see a refresh of our website, which is a good place to find out about our services and to register for upcoming events. For instance, after these estate planning webinars, there's a wonderful Bible talk on Saturday, November 7th at 10 a.m. and then 2 webinars on Medicare in mid-November. Our last event this year is one of our finest traditions, our annual Christmas celebration on Sunday, December 6th at 2 p.m. Pacific. We're looking forward to sharing a wonderful musical program with you for the first time entirely online. We hope you'll begin your Christmas season with us. Arden Wood is a 501c3 nonprofit organization, and we wouldn't be here today without the loving generosity of countless Christian Scientists since 1930, when Arden Wood first opened. Donations account for nearly 35% of our operating budget, which supports our Christian Science Nurses Training Program and our Christian Science nursing services, including skilled care, sheltered care, also known as assisted living, and our visiting Christian Science nursing service all over the greater San Francisco Bay Area. In other news, I'm pleased to report that we have been able to fully function throughout the pandemic. We have patients, sheltered care guests, and independent living residents living here, all actively praying for peace and healing on a local, national, and global level. With great wisdom and alertness, we have also been able to make home visits to those who have been completely isolated while sheltering in place. In other instances, we've been able to offer support over the phone, text, and email. Care means connecting with one another, and that's what Arden Wood is all about. With this in mind, we are delighted to present these informational webinars, and we encourage you to invite a family member or friend to join us for future events. We also have one next week, next Thursday at the same time. Now, let me introduce today's speaker, Edward Pearson. If you joined us for last week's webinar, you already know Ed. He's a Trojan through and through with his undergraduate JD and MBA degrees from the University of Southern California, USC, and he loves baseball, but unfortunately he roots for the wrong team, the Dodgers, even if they are in first place, Ed, I know. You also know Ed has been an estate planning attorney for 95% of his career. He knows what he's talking about. Ed is a partner in Overton, Lyman and Prince, LLP, which claims to be LA's oldest law firm. It's been around since the late 1800s, and he manages the firm. Ed has 2 wonderful adult daughters, one of whom is a lawyer and works with Ed, both of them from their respective homes during this pandemic. He also has 2 very little grandchildren, with another on his way in December. Yay. Finally, Ed has a long history of involvement with the Pasadena Tournament of Roses, which organizes the New Year's Day Rose Parade. It's been canceled for this coming January 1st, but hopefully it'll be back in 2022. If you've never been to the Rose Parade, I highly recommend it for your bucket list. It's truly amazing. Before I turn the program over to Ed, let me explain how you can ask questions. If you look at the bottom of your Zoom screen, you'll see an icon that says Q&A. Click on it, and a screen will appear where you can type in a question. Press submit, and it will arrive here. Another note, please do not use the chat icon, because then it opens up to everybody, and so please don't use the chat icon. We will collect your questions throughout the webinar and save them for the end of Ed's presentation, when he will answer as many as we have time for. And finally, let me say that the information provided in these workshops is not intended to constitute legal advice. All content is for general informational purposes only. Please join me now in welcoming Ed Pearson.
Well, thank you again, John. It's great to be back. And I will say that one of the, I guess, advantages of doing 2 of these sessions is that you can adjust the content to make the 2 make sense in terms of if maybe session number 2, which is connected with who are your decision makers, maybe won't take the full amount of time. I have some things from last week that I wasn't able to complete, and I could do that first. And I want to have us go to one of the early slides, talks about goals of estate planning, which we talked a little bit about last time. And what I want to emphasize here is there really could have been one that either would be labeled 4A or would be inserted after number 4 anyway. And that's really implicit in many ways in all of the other ones. The estate plan that someone creates should have clarity. It should have completeness. It should avoid ambiguity or confusion. And all of those things go to what John mentioned a minute ago about the sister and brother who hadn't spoken for 14 years over an estate dispute. Good estate planning can avoid those kinds of situations and reduce the occasions of disputes, or can reduce the kinds of friction that may occur in a certain case. So keep that in mind as another goal, to be clear, to avoid the issues that might cause some friction at some point in another, in some way. We're now going to move, we ended last time by looking at hypothetical number 1 in the spreadsheet, and we're going to move now to hypothetical number 2. Hypothetical number 2 deals with the subject matter is the form of ownership is unclear. And this gets into this idea of making certain that the estate plan is in fact clear, that everybody sees what the situation is, rather than allowing for some kind of uncertainty. The hypothetical given is one of an individual who has 3 children. And 2 of those children are not geographically nearby. One is near him, and as might make sense, he decides to add that one child onto his bank account. And that's where the ambiguity can come in. What is meant by adding on an individual to a bank account? Sometimes you go to the bank and they assume that what you want is to make that person that you're adding on a joint tenant and joint owner of the account, so that when the individual who created the account dies, the surviving joint tenant will receive the account. But that may or may not have been what, in our case, the man's name is Joe, what Joe wanted. He may have wanted that local daughter to be able to sign checks, to be able to deal with bank officers and so forth. And so he could have, and maybe he intended, to add her as power of attorney on the account. Under power of attorney, the relationship ceases upon the death of the principal. Here it's Joe. And so when Joe dies, the power of attorney ceases and the account is there to be collected by his trust or his estate or whatever may be the case, to be divided equally among all the children. So we don't know what Joe wanted. And that's where clarity is very, very important. Don't leave things unclear. Let's move on to hypothetical number 3. And this is one of, I guess the cautionary tale here is update what you do from time to time. It's all well and good to get life insurance and designate someone as your beneficiary. But it may be that years and years pass before the life insurance is going to be paid to that beneficiary. And in the meantime, you may have very, very different ideas. So the hypothetical here concerns 2 characters named Milo and Otis. You'll recognize that. There's a movie about Milo and Otis. Milo gets his first job. The company offers him a retirement account. And when he fills out the forms, he fills in for beneficiary his best friend, Otis. Years go by, Milo continues to work and gets more and more money into that retirement account. But Milo and Otis lose touch. Milo has long since forgotten that he ever named Otis as beneficiary on the account. He never takes any steps to change it. And what he wants to do is to give everything he has to his brother. So his brother is beneficiary on all of their accounts, beneficiary of his trust. He tells his brother, Sam, you're going to get everything. But when Milo dies, it's Otis that is the named beneficiary on the retirement account. And Otis is going to get the retirement account benefits rather than brother Sam. So the point of this is make sure that you do what you need to do periodically. One of the things that we do at the end of an estate planning engagement is to say that, we strongly advise that perhaps every 3 years, no more than every 5 years, you pull out these documents, you read them over, you give us a call, and we consider whether what you created those number of years ago still makes sense for you. So that's, again, it's a cautionary tale. I have a slide for what I'm going to refer to as non-issues, which I guess is the next one after what's on the screen right now. Yeah, non-issues. These are things that might occur to somebody as potential problems. For instance, you have a mortgage on your home, and like most mortgages, it says something about if there's a transfer of the property, the full balance of the mortgage comes due. It's a due on sale clause would be the verbiage used. Well, when you're putting your real estate into a trust, which, based on what we talked about last week, may be the appropriate estate planning vehicle for you, you can rest assured that that transfer of your residence to the trust will not, in fact, trigger that due on sale clause. Now, that's not to say that other kinds of property that might not happen. The 4-unit rental property that you have, indeed, there might be. But as to the residence, there's a specific prohibition against the lender being able to invoke that provision. One of the things, again, this is more specific to California than to those of you who might not be here. Even if you're not in California, you've probably heard of Prop 13, which has been around now for, I think it's about 45 years, maybe not quite. And what it does is it limits property tax in some cases to acquisition date values. And in some instances, that acquisition date is clear back to 1976. When you, again, if the event occurs that you transfer property into a living trust, is that going to be a so-called change of ownership that would trigger a reassessment? The answer right now is no. Now, Californians have propositions on the ballot for this coming November in which there may be some significant changes to some of the rules under Prop 13. I'm not going to get into that, but it is certainly the case that in all likelihood, at least the protection of a residence from reassessment upon well, actually in every case, the transfer of property into a trust is not going to trigger reassessment. It may be that upon the death of the trustor and the distribution of the trust, there may be reassessment, but even there it's not likely to occur as to residences. A non-issue, or at least what I presume to be a non-issue for most people, is estate taxes, at least for now, for most people. Again, I think I said this last week, if you happen to be one of those people that has $30 million, congratulations, that's wonderful. You also may have some estate tax worries that go with that. But to the vast majority of us who are, well below the current exemptions, estate tax is not something that is right now a factor in much estate planning decision making. That's not to say that things can't change. And it's like so many things, you don't have to be an expert in this, but you do have to be, at least have your antenna up to be able to understand that there could be some changes and to be ready to adjust if in fact that happens. And the other one we listed here is the fact, or the idea of escheat, where if there is if no one claims property, it is sometimes sent to the state financial department, whatever that might happen to be. Here in California, it's the Office of the State Controller, and that the state controller may well be holding funds belonging to various individuals. It's not something that you necessarily need to be concerned about. It's something that would happen automatically if that became relevant. If all beneficiaries predeceased and there was no one to receive it, it might end up going to the state until such time as the person's entitled to it, whoever they may be, could take the steps necessary to reclaim it from the state. It is something that on occasion you might be, I don't know, is interested in doing, go to the state controller's website. You can search under unclaimed property for yourself, for your relatives, for people that you know, and you may find that there's money out there that you've long since forgotten. I think the last time I checked, there's some account that I had which might have 20 cents in it that the state now holds on my behalf. Probably not worth trying to reclaim that one. But the big subject that we're going to be covering today is contained within the title of this talk. Who will be your decision makers? And I want to introduce the subject by telling you a little bit about what comes up fairly frequently in my law practice, and that is the concept of conservatorship. In conservatorship, or I should say it this way, conservatorship is a means by which it's a court proceeding by which the affairs of a disabled or incapacitated is the proper word, individual are administered. And those factors, those things that must be done fall into two categories. Either they pertain to someone's person or to someone's estate. And so a typical conservatorship will be either for the person of the disabled, incapacitated individual or the estate of that individual, or potentially for both. And I think that's a very good way for you to look at the kinds of persons that you want to be handling matters. There are things that are personal. Are you going to have food, clothing, and shelter? Who's going to attend to your medical care in the event that you cannot attend to those things yourself? Then there's the financial aspect of things. Who is it that's going to manage your financial affairs, either during your lifetime, if you become unable to do so yourself, or upon your passing, who's going to take care of the financial affairs going forward? A very similar kind of thing, and this may or may not apply to the people that are watching today, would be with regard to young children. You need to name guardians for very young children, someone who will raise them, and someone who will take care of their financial health as well. So that may or may not be the same person. It's possible that you will name either a guardian who is going to raise kids and perhaps a different guardian to manage the kids' money, just like it's possible that you would have done the same with a conservator in order to avoid conservatorship, which I described last time as sort of lifetime probate. You have different documents that come into play. And so with regard to your financial affairs, it may well be that you've created a trust and that it will be a trustee, a successor to yourself, who will be the one that handles those kinds of issues, the financial matters. But you will also be naming someone to take care of personal affairs as well. The usual document for that is sometimes referred to as a power of attorney for healthcare, or here in California, the nomenclature is now such that we refer to that as an advanced healthcare directive. You may hear the word durable in connection with powers of attorney. And the reason that the word durable comes into play is that under old law, which existed until probably the mid-1970s, a power of attorney would cease upon the incapacity of the principal. The person making the power of attorney, giving someone else power of attorney, if they became incapacitated, the power of attorney would go poof and the relationship would no longer exist. The law was changed, as I said, I would put it in the mid-1970s, maybe early 80s, where it became possible to state in a document that this power of attorney will continue in force even given the incapacity of the principal. And it only makes sense if the purpose of it is to put somebody in place if you can no longer handle something yourself. You want it to be durable. You want it to carry on, even if the individual can no longer make decisions for himself or herself. And so when a healthcare power of attorney was first developed, it was usually referred to as a durable power of attorney for healthcare, the DPAHC. Well, now we use another set of letters, the AHCD, Advanced Healthcare Directive, by which you can appoint someone to take care of healthcare decisions on your behalf if you can no longer make them yourself, and one which will carry on even if you should become incapacitated in some way. It's also possible to do an AHCD that only springs into being upon incapacity, a so-called springing power, where upon the determination that the principal lacks capacity, only then does the individual who is named as agent become able to make decisions for that person. So you can get a flavor of what you're looking for there, particularly for Christian Scientists. You may be looking for someone whom you know will carry out decisions that you would want made with regard to your healthcare. And therefore, you might be looking perhaps a little farther afield than others might. Typically, most often, a healthcare power of attorney, an AHCD, will designate a family member, a spouse, a child, that kind of thing. But it doesn't have to be that way. And if there is reason for you to do so, you can name some trusted individual to make those decisions on your behalf. In addition, you have the opportunity in the document to specify the kind of healthcare that you would want. Now, the usual, let's call it the normal advanced directive, will include a provision about what to do in the event that there's a life-threatening illness, terminal disease, or something of that nature. And there will be either a box to check or perhaps a line to sign, which is, I think the common terminology or the shorthand terminology would be pull the plug and do not have heroic measures taken to keep someone alive. So while that is usually put into a power of attorney, there is also ample space to include a whole lot else. And there are powers of attorney that are specifically designed to meet the needs of a Christian Scientist because they will specify a little bit more than just generic power of attorney would about what kind of treatment you desire. And so you can say in there that I'm a Christian Scientist, and if in effect, I want Christian Science treatment. And yes, it goes on beyond that. It's more complicated than that, but that's essentially what it gets down to. And we did talk about this last week, and John assured me and all of us that there is a power of attorney, an advance directive that is geared for Christian Scientists that is there on the website for Arden Wood. Now, that's kind of a personal aspect of things. So is a financial power of attorney. Even if you put most of your assets into the trust, there may be things outside, and you may desire to have that opportunity for someone else to assist you with regard to financial transactions or financial matters. Perhaps there's some insurance dispute that someone else, you would prefer that they work that out on your behalf. Maybe there needs to be an application for Social Security and you can't do it yourself or can't figure it out and you want someone else to do that on your behalf. That's where a financial power of attorney comes in. It too is a durable power of attorney for assets, for financial assets. There's at least in California, a statutory form that I will send out to people with instructions about how to make it happen. And, you can, again, see the logic of who you would want. It's got to be somebody that is completely trustworthy and is not going to take advantage of their situation to rip you off. It's got to be somebody that is perhaps savvy about financial affairs as opposed to, wouldn't know the first thing about writing out a check or something like that. So you can kind of gear what you need to do to the role that people are going to play. And probably the most important of those persons is the person that you're going to name as a successor trustee of your trust. What I've on the screen listed a whole lot of elements to this decision. Are you going to be looking to appoint family members, or are your family members not the kind that you would want, or perhaps they're not really in a position to be able to assist you by acting as your successor as trustee? We will talk about, and I think that it's usually the subject of an estate planning meeting about who's going to be your trustee after you pass. But it is conceivable that this trustee might come into office upon the incapacity of the trustor, the person creating the trust. It may be that the person that's the trustor simply doesn't want to continue to serve any longer. And so it may be that you're going to have somebody as a trustee for you even while you're still living. But in any event, you've got to gear the office to the capacities, the capabilities, I would guess, of the likely persons who can serve. So you may have family members, and that's could be ideal. Family members will typically, although not always, do the work that's necessary for perhaps little or no compensation. It may be that family members really aren't available, or even if they are, that they may not carry out the full administration of the trust, which we'll get to in just a minute. So there may be occasions when you're going to go to non-family members, and we'll talk again about who some of those could be. So we've kind of talked about number 2 there, that this individual or this institution could become a trustee during the trustor's lifetime, or in the event of a married couple, which typically the married couple would both serve as trustees, and then the one, upon the death or incapacity of one of the spouses, the other would serve alone as trustee. That's the usual. But it could be that there is going to be a time during the lifetime of the trustee, of the trustor or the trustors, where another trustee is going to come in. Term of service is also a very big factor. If you're going to have a trust that's going to carry on for years and years and years after your passing, you're going to need either a long list of individuals, or you're going to need potentially an institutional trustee somewhere down the road. Now, if as many trusts provide, if your trust is going to be one that will terminate shortly after the death of the trustor or trustors, and will distribute, all to kids, all to charity, whatever it may be, that term of service for that trustee is going to be a matter of months instead of a matter of years. And so it may be that naming one or two is going to be sufficient. But if there's a trust that's going to carry on because you're not going to let your children have it until they get to be age 35 and they are in their teens, so that there's a 20-year potential for that trustee, you need to be cognizant of that. And you probably don't want to name your 82-year-old uncle as a trustee in that instance. Yes, he may be the best. Now, you can name him and give him the ability to designate his own successor. And that really gets us down to number 4. It has always been the case that we tell people name 1, 2, 3, but in any event, we usually state that those individuals can appoint their own successors as trustees. And that will often be a way of making certain that that potentially long-term trust will always have a trustee in place. There's a level of expertise that may be required in certain trusts. If there is a large amount of real property, for instance, you might need somebody who's has expertise in the field of dealing with property, managing units, or whatever it may be. You may have significant investment assets, and you need somebody with investment expertise. That will lead you perhaps to certain individuals, making certain that those individuals are put in touch with the people that have been managing your money, so that when it falls to a trustee to do so, perhaps they already have a resource for where to go for that. The very nature of the document is a trust, and it therefore calls for trustworthiness. You need somebody who you know will do the job, who will make certain that if there are multiple beneficiaries, that they are treated fairly, that is not going to fall down on the job, or worse, misuse the position. So that's got to be a consideration in whom you pick. Compensation. I mentioned that family members might indeed, if they are trustees, waive their right to receive compensation, but trustees are entitled to it. It's a job. There's work that needs to be done. It's going to take time, and you should be aware of the fact that even a family member trustee is going to say, I've been doing this work and I need to be paid. There are a couple of ways that trustees are compensated. One is the way that I think certainly lawyers would be familiar with. You record time. You keep a log of your time. You add up that time. You apply an hourly rate to the time spent, and that becomes the fee that is charged. But that can be a bit of a problem because it means record keeping, which itself is going to be time consuming. And so through the years, what has been developed is the use of a percentage fee for a trustee. This was originally popularized by banks that would act as trustees. And so they would charge a certain rate. Sometimes it would be a declining rate, a certain amount on the first $5 million, let's say, a somewhat lesser rate on the next $5 million, and so forth. But the idea of a percentage rate has really become, I would say, more the norm today than the hourly rate times certain number of hours kind of approach. I think it's still fair to say that as a rule of thumb, you could probably count on a trustee receiving 1% of the value of the trust on an annual basis. So if the trust is worth $10 million, there would be a fee of, what does that turn out to be? That's about $100,000 a year on a $10 million, except that in that $10 million rate, you probably would have a break somewhere, maybe 5 million at 1% and the next 5 at 0.6% or something like that. But the point is, know going in there and in connection with the trust that you may well have a trustee who's going to be compensated. It just is one of the many factors to keep in mind so that you're not surprised. And of course, there's the idea of trustees and beneficiaries potentially coming into conflict. Taking the family example, I'll give you my example. I'm one of 3 kids, and upon the death of our parents, my siblings and I had to deal with my parents' estates. My sister, I don't know if she wanted the position, but she ended up with the position of trustee and had to wrestle sometimes with her 2 brothers. Now, I think we got along really well, and it wasn't much of a problem, but there could have been. And there was certainly the potential for that in trying to decide who was going to get what and so forth. So it is something to kind of watch out for. Yes, the easiest thing is just to say, all 3 of you kids are trustees. And by the way, the document probably will provide, as ours did, that if all 3 are named, any one of them can bow out in favor of the other 2. And so if 2 bow out, it's the one. And my sister got the short straw. Sorry. So given the fact that sometimes a trustee is going to have a stake in how the trust is administered, it may be that you want to go outside the family circle, that you want the independence of someone else as a trustee. Again, knowing that the independent trustee is most certainly going to be seeking compensation for doing the work, but it isn't a tremendous fee, and it may well be the best money ever spent to make sure that it's done right, that it's done fairly, that it's done with a minimum of acrimony. So independence may well be a cornerstone for you. You can name co-trustees. We talked about expertise, and there may be the kind that is can put together a cooperative atmosphere among the beneficiaries. There may be a trustee who is perhaps hard to deal with, but is brilliant at paperwork and being organized and running real estate or whatever it may be. So co-trustees may make sense in certain circumstances. By all means, consider it. I listed down toward the bottom some of the potential institutional trustees that you can turn to. Now, banks have been the trustees for a very, very long time. It is harder today to find banks to do this kind of work unless trusts are very, very large. I don't know what, I'm sure that there are publications that would tell you what different banks would accept as a minimum size account, but it's probably in the millions of dollars. You're probably not going to find a bank that's going to be willing to take on a $700,000 trust, or even $1.2 million or something like that. You would have to check with the potential banks that you are considering about what their minimum size trust would be and what their compensation rate would be. How do they differ from other banks in terms of fixing trustee fees? There are private trust companies where, let me go back one step to talk about banks. What would happen in the bank scenario, there would be a trust officer, the individual who is charged with the obeying the terms of the trust, carrying out the terms of the trust. And so they would have the relationship with the beneficiaries. They'd be the one that would be calling them on the phone if it ever was necessary. They'd be the go-between. But the bank would also have a number of other officers handling matters, typically investments. So you've got the trust officer, you've got the investment officer, you may have a real estate officer. It can be a multi-level situation. And it's because of that, because there are so many individuals involved, that they have to pay all those individuals. And so that's why you're not going to be seeing a small trust being administered in that fashion. Private trust companies can do the same, and at least according to their ways of looking at things, they can do so more efficiently, which does allow them to take on perhaps smaller trusts. Now, they may have the same kinds of rules about minimum trust sizes, but it is an option, and the idea would be that they might be more responsive. One other thing about banks is that, again, I don't want to speak too generally, but banks have lost the kind of connection to certain communities that they used to have. The last time I had to deal with a bank trustee, all of the persons that I was dealing with were in Utah. And so even though, nowadays phone and email and so forth, it can be just as efficient, there's something different about it. And that fact, again, may lead people to consider a local private trust company, because there might be a sense that they're more attuned to the community in which the trustors reside. There are nowadays, and this is probably a little bit more recent, there are trust companies that are affiliated with investment companies. And so whether it's a Merrill Lynch or a Morgan Stanley or one of those, they may have an arm that is, they still want the investment business. They still want to keep the control of, and it's lucrative to them to keep managing the investments that you have developed and that you have entrusted to them. But they have not until more recently been able to act as a trustee. But now there are usually affiliated companies with the different investment institutions that will allow them to keep the money. So I don't know the names of these things. There's one I am aware of. It is actually just called the Private Trust Company, and it's affiliated with one of the big money managers in the United States. So that's an option, particularly if you're satisfied with the institution that has been managing your funds. They either have their own in-house trust company, or they may have an affiliation with a private trust company, as we labeled in letter B there, which allows the private trust company may do all of the trust work, the dealing with beneficiaries, the accounting to beneficiaries, the filing tax returns, but the investments can be left with, the Smith money managing firm, whatever it might be. And lastly, on my list of potential institutional trustees are professional fiduciaries. This is an industry, at least in California, that developed around the 1980s. In the event that family members could no longer act as conservator, and that's how these private fiduciaries, professional fiduciaries began. They started out as conservators. If individuals could not take care of an elderly person and do all the work financially or personally that needed to be done, maybe there was nobody within thousands of miles. The alternative had been that the public guardian of the different counties of California would be put in that position. Public guardian they're a wonderful bunch of people, but they had too much to do, and it was generally thought to be an inadequate solution. So this industry of private professional fiduciaries developed, and they were initially professional conservators, and gradually, as it's not uncommon, they expanded their field of business, particularly as people began to create living trusts, which made unnecessary the idea of a conservatorship of the estate of an individual. Private fiduciaries began to act in that role of trustee for the very reasons that they were initially conservators. There were no persons either able or near enough at hand to be able to take on the role of trustee, and so private fiduciaries began to do so. From my own experience, I know that professional fiduciaries will take cases that are much, much lesser in value than those that a bank might take. So it is an option for people, at least in California. Again, I don't know what it is like elsewhere. We have the Professional Fiduciaries of California, PFAC. You could always go to their website and look for potential private trustees within, it's, I'm sure, organized by county, and you could look in different counties and find out what they're all about. I kind of feel like that's a good stopping point. Oh, one other thing I should say is about guardians. And I don't know that that necessarily applies to many of you watching here, but in the old days, I don't know when the old days were, but you used to put the nomination of a guardian into a will. It is more common today to have a separate document. a standalone document, nomination of guardians. And you nominate guardians with the same two things in mind. Who's going to take my place in raising this child? Who's going to determine their religious upbringing? Who's going to deal with their schooling? The kinds of things that go into making somebody a person. But then there's the other aspect of it. Who's going to take care of their money? And so even if you have set up a trust which provides for the children financially, you probably still have a nomination of guardian form to make certain that you appoint somebody that you believe will do right by your child in terms of taking him or her into their home to make certain that they are raised as you would want them to be raised. So that's another decision maker. The one that we've talked most about tonight is trustee, but realize that there are others out there, powers of attorney or agents under power of attorney, agents under an advanced healthcare directive. And for those of you that still write wills, and there are going to be many of you, it's an executor. The executor has that same job that a trustee does, managing money or taking care of money during the pendency of an estate proceeding. And I think with that, it's probably time, John, for us to perhaps see if there are some questions that we can answer, and then we'll be finished with these sessions.
Thank you, Ed. The details you shared about choosing the right decision makers are so helpful, especially the reminder to review your estate plan every 3 years, at least every 3 years, and to have an estate plan. Before we go to questions, let's take a quick poll. It's the same one that you took last week if you were with us. So we're going to have the poll come up on the screen. Just quickly, just click on the answer to when was the last time you reviewed, updated your estate plan? Just take one moment and do that. Okay. We'll click on that. Okay. We'll just go right to questions. I've got several. Thank you all for sending them in. The first one is, Ed, my bank can handle my affairs after I'm gone. Is it wise to have a trusted friend in addition to oversee that my wishes are carried out?
Well, I mean, it's not stated there exactly what the role of the bank is. I'm assuming it's trustee. And that may well be sufficient. I can see why you would want to have that trusted friend in place, though, as a co-trustee, perhaps. They're going to be the ones that maybe give a little bit of nudge to the bank trust officer. You know, why has it taken you 2 months to do thus and such? Let's get going. You know, I know that these nieces and nephews of the decedent are hurting for money, or not hurting, but they need the money. Can you make sure that you make this happen? I don't want to sound like I'm down on banks. I'm not, but they can be unresponsive. We know that. And if you have somebody to give them a little kick once in a while, it's not a bad idea.
That's perfect. Oh, here come the results. Let me just, so let's just quickly, when was the last time you reviewed your, or updated your estate? 13% or 13 or 29% said 1 year ago. 5 to 10 years ago, 31%, 10 plus years ago, 20%. And those who said they didn't have an estate plan is 20% as well. So very interesting information. Thank you all for taking the poll. Question 2, this is a little bit long, so bear with me. My question is about designated power of attorneys. I've been told that I need at least 3 individuals, an attorney in fact, plus 2 backups, to serve consecutively should the need arise. However, my family is very small now. At present, I have only 2 individuals to serve, a relative and a friend. My attorney has offered to serve as a second backup. Here's my primary question. It has been recommended that I include a provision in my DPOA that would allow the attorney in fact to appoint successor attorneys in fact, in the event that the ones I have appointed couldn't serve and I wasn't capable of appointing others. It would potentially forestall court involvement. While I can see the reasoning for this, I'm not particularly comfortable with the attorney in fact appointing successor attorneys in fact, and those attorneys in fact also having the attorney to appoint. In short, strangers potentially having a lot of power. Do you consider this an acceptable way to appoint attorneys in fact, or are there better and safer ways to handle this?
I don't think I would call it acceptable. Yes, I might not call it ideal. And yes, it is wise to name at least a couple of potential agents under the power of attorney. I think that it may be, in the situation described, it may be best to give the trusted friend the ability to designate successors, or for that matter, the family member. If it's somebody that is, again, you wouldn't be appointing somebody unless you felt that they were worthy of the position and worthy of your trust to be able to name them. One of their potential strengths would be to recognize when the family member says, I can't do this anymore, I'm going to appoint so-and-so. Give the individuals rather than the lawyer that same power to appoint successors. It's possible that neither of them will do it. They may fail to name successors, in which case it's, I think, a reasonable means to make sure that somebody remains in place to give that third person, the lawyer, the ability to name his successor as well.
Okay. Question 3, under advanced healthcare directives, could you please explain DNRs, or do not resuscitate, and how they work for a Christian Scientist? Bottom line, what does it really mean? My husband just passed, he was not a Christian Scientist, in a hospital with a DNR, so I'm a little confused. Please speak to this, as I'll be moving to California soon and I'll need to update my documents for my new state.
Well, I mean, it's a separate document. The DNR is separate from the advanced directive, and it is it's do not resuscitate, and that's exactly what it is designed to do, is to alert individuals that they are not to be resuscitated under certain conditions. So one of the things that is sometimes advised is to have a DNR prominently displayed in one's home, whether it's plastered on the refrigerator or something like that. If someone is stricken in their residence and the paramedics arrive, in the event that there's a DNR, it may, the simple fact is nobody quite knows what's going to happen in certain circumstances, because so much depends upon the point of view of the persons that are on the scene dealing with the individual. In the hospital setting, where they are used to this kind of thing, the DNR is part of the chart, and they will see that. And if there has been some event that has means resuscitation would be necessary, the presence of the DNR will make that not happen, should make that not happen, but there's no guarantee. one of the other things we have here, and I think, again, this is probably something that's used elsewhere, it's called Physician's Orders for Life-Sustaining Treatment, a POLST, P-O-L-S-T. And it's the same kind of thing. In advance, you tell your doctor, this is what I want done, and the doctor, separately from the DNR, includes it within the chart. So if the doctor is not on the scene, but some other doctor comes in, breaks open the chart, there it is. The POLST is right there, smack dab in front of him, and he can say, do not use life, the paddles or whatever that might be necessary to revive the individual. I'm talking about hospital settings and what doctors do and things like that. Christian Scientists have it tough, and you know that. You don't know what someone is going to do in the presence of those documents. And so I wish I could be more definitive about it, but it's an unknown to some extent.
Thank you. Question 4. Now here's a curveball for you. How to deal with disagreements regarding who beneficiaries are when the wife wants her children to be beneficiaries and her second husband wants charities to become beneficiaries instead of the case with his Roth IRA.
His Roth IRA.
He would like it to go to a charity, and it sounds like the second spouse would like to go to the children.
I think there's a little bit of an issue about, at least for California, community property law. What was the source of the funds that became the Roth IRA? With the little bit of facts that are stated there, I would tend to believe that the Roth is separate property. That doesn't mean that he can direct it completely, but I think that in large measure that's going to be indeed the case, and that it will all go to the charity. Now, there's federal law that gives spouses certain rights, and I think a Roth IRA might well be one of them. I'm going to have to say, for the most part, this is an I don't know, but I think that it would be incumbent upon, you might have to go to the CPA to find out just what are the rules about the ability of the account holder to take out it was not so much that it wouldn't go to the spouse, it was direct to charity rather than, so was the initial beneficiary designation of the Roth to go to the spouse if living, and if not, then it would probably go to the kids, to the charities. It's not an easy one.
Thank you. Next question. We need to update our estate plan. It's a revocable trust now that our children are grown. And we're aware that there may be special considerations given that we're students of Christian Science. Would your firm be available to help with this, even though we're in Northern California and you're in Southern California?
Well, the easy answer is yes. I do work up and down the state. Obviously, the vast majority of what I do is done in Southern California. But, we're living in times where things are being done totally differently than ever before. I'm trying to remember, I think I had a client meeting face-to-face in February. And ever since then, it's been Zoom. And even before that, it was largely done by email and by phone. And so the notion that I could not represent someone in Northern California is, that That's just not the case any longer.
Great. And we'll have everyone's Ed's contact information at the end. Here we've got a few more questions. I guess this is a point of fact. California's Proposition 13 was voted on in 1978. Good to know. Next question. Can a person who has been granted power of attorney in turn grant this to someone else on your behalf? That is, you ask them to serve as your POA, but then they become unable or unwilling to do it. Can they find someone else to act on your behalf?
If it is specifically authorized in the first power of attorney, if you choose to designate person A as your agent, you can authorize certain things for A to do. If you say nothing, well, actually, I don't think anyone would ever say nothing. There are certain powers that basically all you have to do is check a line. You know, they have this power to deal with banking, to deal with real estate, whatever it may be. But if you specifically authorize the agent to take on certain roles, including designating a successor agent, that would be okay.
Okay. Just a few more here. I know we're going over, but and I think I'm going to ask this question, and then I'm going to request that sir or ma'am, I don't know, it says anonymous attendee, that you would email Ed, but I'm going to ask the question so he is aware of it. But Ed can email you back privately. Are any private trust companies you recommend in Southern California for $1 million plus trust? I'll just leave it there, and you can correspond via email. Any PFACs you recommend in Santa Barbara or Ventura counties? I'll let that, I don't think we want to do recommendations here, but again, you can email privately. Who finds out if a person is living alone has died?
I don't know the answer to that. You know, what has happened is that there will be a welfare check. You know, someone will, you know, I haven't been able to get in touch with so-and-so by phone for a week. It's not the kind of person that would ignore my phone calls. You call the local police department and say, would you go to such and such address and see if all is okay with my friend. And it's sometimes that's indeed what happens, is the welfare check to find out if all is indeed okay. But I think there's probably no, you know, formula or no consistent way that is done.
Okay, I've got 3 questions, and we'll close with 3 questions here.
Mm-hmm.
Inherited beneficiary contingency traditional IRA fund. Was recently told I had no access. Wife passed away a few years ago. He may also, yet fiduciary wanted to close services. Yet, I'm not sure what that last son had record. I was sole beneficiary. Still no update with fiduciary. It's kind of a difficult to understand. I guess they are trying to figure out when they would be inheriting this particular traditional IRA fund.
Yeah, I don't know. Kind of like need more facts.
Need more facts. Maybe that could be emailed to Ed, please.
Yeah.
2 more. Is do not resuscitate similar to comfort care only, not having lungs pumped, etc.?
I think that's I would call that a different kind of degree of intervention. Although it may well be, kind of depends on you know what the medical definition of resuscitate is. But I think of those 2 things as separate items. I think of the comfort as more of a perhaps you know, I don't know. Hard to say.
Mhm.
But I don't think so.
Last question. If you have individual stocks with a named beneficiary, do you have to put the stock in a trust?
And the answer is no, if in fact things go the way you anticipate, where if you have named individuals to receive those and they are all alive and kicking when you pass, then those stocks can go directly to them, no probate, no anything. They get all the benefits of that. It sometimes is a little more, it's more work for them. They're going to have to get those stocks and deal with a transfer agent. If in fact you take all of your stocks and put them with a stockbroker or some kind of institution, and then you can put the account into the trust, then whoever's handling that account on your behalf can more readily get the proceeds of those stocks or the stocks themselves into the hands of the persons that you name in your trust. The other way is going to work. It just has a few more potential problems if things don't happen the sort of anticipated way in terms of sequence of dying and things like that.
Wonderful. Thank you, Ed, and everyone for attending this workshop today. We want to be sure all of us is well informed on these kind of practical issues. We don't want to ignore them. Once again, a replay of both webinars is available on our website, ardenwood.org, under Events. Next week, same day and same time, we'll hear from Amanda Whiteman on another key element of your estate plan. What are your giving options, and why is a legacy letter important? In other words, when you leave this human experience, will your loved ones know why you made the choices and decisions you made? That can save a lot of heartache. This is the third and final webinar in this series. If you have more questions, please feel free to be in touch with Ed or me. We'll be happy to talk with you. Our contact information will appear on your screen in just a moment. Again, thank you for joining us today. We hope to see you again next week.